Good morning. We, uh, Several times, uh, several judges, retired judges, used to openly declare that the verdict of Supreme Court are hardly understandable. The word hardly normally, is being used for careful consideration. See, this is the case AAR 2024 Supreme Court 3172. AAR 2024 Supreme Court 3172. This Rajendra Bhagwani Umrania versus State of Gujarat. I am referring this case for certain concept as well as for young lawyers who can follow the judgment and can work out for claiming compensation if you are defending or you are assisting the victims. The victimology, since being introduced by way of amending 257 and 257A CRPC, kindly go through it again and again. Here I will just read out, I will just discuss with you about facts of the case. Facts of the case that two named persons and three unnamed persons were prosecuted for offences under section 147, 148, 149, 427, 323, 325, 506 Part 2 and 384 IPC and section 135 of Gujarat Police Act. All others were acquitted except A1 and A2 and they were sentenced to undergo imprisonment for under 325 5 years and 323 1 year, and also some fine amount were imposed and appeals, counter appeals were filed. Then what had happened finally, they out of 5 appeals, only 2 appeals were disposed, modifying the sentence 325 4 years to 5 years to 4 years, and fine amounts were unaltered. But however, the Honorable High Court seems to have imposed compensation for sum of rupees 2.5 lakhs by both the accused under section 357 CRPC, and if they paid the amount and they need not undergo 4 years imprisonment. This is what the Honorable High Court has done it, and this went to Supreme Court. Supreme Court has categorically held that compensation, victim compensation is nothing to do with the reduction of sentence. So, victim compensation is not punitive measure, it is a restitutory nature. That was their finding. They said that the modifying the sentence, relaxing the sentence by Honorable High Court was not correct. But finally what the Supreme Court did, they said since 12 years already been over and 5 lakhs already been deposited, they again said you pay further 5 lakhs, further amount of 5 lakhs, that is in all 10 lakhs, and they are not allowed to undergo sentence. This is what normally, what can we say, this is the judgment delivered. That was a different aspect, stating that courts have no power to substitute the compensation in lieu of sentence. But this final verdict of the Supreme Court says since they were already out of bail for 12 years, so there was some whatever it may be, this process of paying compensation, this is called a retroactive principle. Retroactive, not retributive. Is not neither retributive nor reformative, but it's a retroactive principles. Just keep this judgment on file and record. Best wishes.